Good afternoon, sir. Good afternoon, sir. Am I audible?
And the order of Honorable Additional District Judge of Alipur Road. I cannot. Why? Why? So, in terms of the order of Honorable Calcutta High Court, dated 27/2021, in WPA number 10913 of 2021, and the order of the Honorable Additional District Judge of Alipur Court, by an order dated 3 feet 2021 and 27/8/2021, passed in TS 27 of 2018. The petitioner, Shri Kanishk Sinha, has been asked to be present here, and we have been asked to give him a hearing. So, in accordance with these orders, Mr. Sinha is here. He said that he wanted to be here through VC, so we have given this opportunity in compliance with court's orders. Mr. Sinha, you can make your representation. You have half an hour time. After that, for 15 minutes, we'll have any clarifications or question and answers. Thank you. Mr. Sinha, you are smiling.
Yeah, good afternoon, sir. Thank you for giving me the opportunity of hearing before Your Honor. Sir, firstly, I would like to reiterate some points which are very much necessary for adjudication of this case. On 17 June 2015, there was an injunction order passed by Honorable Calcutta High Court, whereby and whereunder the manufacturers, private companies were restrained from infringing the plaintiff's patent in relation to eco-friendly vehicle. Eco-friendly vehicle. 17 June 2015 in GA number 3378 of 2015. It was ordered by the Honorable Calcutta High Court. The matter gone up to Supreme Court, and the Supreme Court also upheld that order in the subsequent SLP. Thereafter, one suit has been filed. So government is saying that we are not aware of this order. On 18th 2016, there was a High Court direction upon the central government to upon the then Secretary Morth, Mr. Sanjay Mitro, I think on that time Secretary Morth post was holding by him. So he conducted a hearing with me and said that your patent is a subject matter of a state, we can't do anything. And that letter was challenged by me before the Calcutta High Court, and Calcutta High Court said that Ministry of Commerce and Industry and Department of Industrial Policy and Promotion has nothing to do with this, and set aside that communication and said that decision has to be taken by your honor. So thereafter, registrations were going on to the electric vehicles despite subsisting order of injunction, and there were no enforcement in this regard. So I already got the injunction, but it was not followed by the state and central government, and that's why I filed a suit, title suit number 27 of 2018, whereby you have been impleaded as a ministry in defendant number 29 and 30 onwards. So in that suit, the matter was taken up under Order 39, Rule 1 and 2 for temporary injunction, and in that matter, the learned additional district judge refused the injunction on the ground that your rights have been already protected by the High Court, so there is no need to get a fresh injunction. Thereafter, I filed an appeal before the Honorable Calcutta High Court, before the Honorable Division Bench, and Honorable Division Bench said that this order is not as per the law, and directed the additional district judge to reconsider the matter and pass a fresh reasoned order on the said matter after giving opportunity of hearing to your honor and other defendants, and the court has also granted you option to file written objection to that, which which you have not availed, and due to it was not availed of, the court passed an order of injunction against you, that to restraining the state and central government from infringing my patent with regard to eco-friendly vehicles. And on that pretext, the ministry has issued many notifications regarding the electric vehicle violating the court's order, and due to which millions of registration has been granted by the state authorities owing to the Morth notification. So the problem is that the central government yesterday, day before yesterday, when I visited to the learned court below, I found a letter written by the central government to the learned additional district judge in a contempt proceeding, which is very much contemptuous, because how a defendant can send a letter to the judge, concerned judge, saying that I have wrote to the patent office, and patent office confirmed the patent, and we are not concerned with the party, and only private parties are concerned. So private parties were restrained earlier in 2015 order. Despite that, your ministry has continued to pass notifications, due to which my patent has my rights has been jeopardized in a huge manner. So now the thing is that on 24/2/2020, the learned additional district judge ordered the state and central government to stop the registrations of all the electric vehicles. It was recorded in two-folded manner. First, court has observed that order of injunction on eco-friendly vehicle dated 17 June 2015 was binding on all the registering authorities. Court has observed this. Thereafter, court has said that immediately stop the registration of e-rickshaws, and you are the party in that proceedings. You have appeared also. Despite that, ministry has issued a newspaper notification that 2 crore registration of e-rickshaw has been granted. So in that context, I sought a compensation from your ministry of 2 lakh crore, in which Mr. Nitin Gadkari is also party, and court has also directed the police authorities to file the report, investigation report under section 13DI of the Prevention of Corruption Act in a FIR lodged against Mr. Nitin Gadkari. So I categorically again and again requested the ministry to not to grant any registration, comply with the court's order, but ministry, despite being a state, despite being a government, having a vested interest in the matter, and continue to grant registrations, which is very much jeopardizing my right and also the international obligation upon the government of India, because government is the PCT member, government is a signatory in a Geneva Treaty. If the government continue to infringe the patent intellectual property rights of its citizens, then it will be a futile exercise before the international forum, because if I brought these issues in the international forum, no company will invest into our country. So the thing is that at first, government has to follow the court's order in true letter and spirit. I first request for compliance of the court's order. 24/2/2020, court ordered your ministry to stop the registration. On 5/12/2020, court order, which was challenged before the Supreme Court, and Supreme Court, after granting the leave, dismissed the SLP. Few people file appeal in the High Court, and few people file appeal in the Supreme Court. When the Supreme Court, after granting the leave under Article 131, dismissed the appeal as withdrawn, then it will be construed to mean that order has been upheld by final court of appeal. Then High Court appeal itself become infructuous. Secondly, there is no scope of changing that order. Secondly, on 5/12/2020, court ordered your ministry, court granted leave that you can grant registration provided my license NOC must be there. Now there is a SOP of 1st May 2019 of Morth, whereby Morth has stated that every registration has to be granted by Vahan e-module. So if your ministry wants to comply with this order, which is very much imperative, unless you got the stay order from the upper forum, because order got upheld from the Supreme Court. So there is no scope of changing this order. So if you want to comply with this order, which is your obligation, then you must have to give me the link in the Vahan e-module, so that I can get my royalty, and my grievances will be redressed by that score. And because of this grant of registration and issuance of various notifications of electric vehicle, my patent is highly jeopardizing, sir. So I request for compliance of the court's order dated 24/2020 first, second 5/12/2020, third 3/3/2021, fourth 27th August 2021. I repeat again, as per the 5/12/2020 liberty, the court has granted you liberty you can grant registration provided my NOC must be there under section 69 and 70 of the Patent Act. which you have not availed of, and you have continued to issue the various notifications for which contempt proceedings has been filed before the court. Second, when there is a subsisting order of injunction, the central government is bound under section 102 of clause 3 of Patent Act 1970 that if you infringe my patent, if you use my patent, you have to pay me the royalty. And there is a shall expression, there is no maybe. So government has to pay the royalty. So first, if ministry decides to not to give me access in the Vahan module, then ministry has to take the responsibility and pay the royalty. Then ministry let ministry collect this royalty for my behalf and pay it to me, because it's not possible for me to file cases again and again and run pillar to post for justice. You are the government, you must protect my right. I am a citizen of yours, I pay the taxes, and I am ready to pay the GST in the patent royalty collected. So it will be good for government revenue also. So I think when the government of India has granted the patent and took the renewal fees, then government must take the responsibility to have it complied in our country in true letter and spirit. Fourthly, fourthly, there is a notification which was issued by the Ministry of Road Transport and Highways after the order of injunction. The Ministry of Road Transport and Highways on 18 to 2016, having the knowledge about the order of injunction by the Calcutta High Court. Despite that, whatever notifications issued by the MORTH has to be withdrawn first. Second hand, whatever registrations granted in Pan India, the royalty has to be paid by the central government if the link is not granted to me. Then in that event, royalty has to be paid by the government of India. And fifthly, I want to know, I praise for providing the file notings on which basis those notifications were issued. Because after grant of patent, the patent office become functus officio. There is no role of patent office to play. But despite that, ministry has continued to send my letters representation to the Department of Industrial Policy and Promotion, which is very much futile exercise by the Calcutta High Court judgment in 23rd June 2016, which was ruled by Honorable Justice Somin Sen. So this is my humble submission. If you wanna having any clarification or question, may kindly ask.
So, is your representation complete?
My representation is 16.4. It is my written notes of submission complete. My representation, may I take your honor to my representation of 16/4/2016? May kindly.
Have you said everything you wanted to say?
No, sir. I have said about my written notes of submission. About my representation, I am now checking it up. My representation, I am opening now. Is
you got 20 minutes more. You can say whatever you want.
Yes, sir.
In next 20 minutes.
Yes, sir. No problem.
Please go ahead.
Yeah, sir. I am referring to page number 52, annexure P10 of the writ petition number 10913 of 2021. Page number 52, annexure P10, sir. Yeah. So, in this representation, the operative part will start from page number 56. So, in the first part of my representation, I have informed the ministry about the subsisting order of injunction, where there it was ordered inter alia, let there be an order of injunction restraining the respondent from repeating any such infringement of the plaintiff's patent as disclosed in Annexure P1 of the application till disposal of the suit, and respondents are further restrained from registration of battery operated eco-friendly rickshaws till disposal of the suit. And in the upper paragraph, the court has ordered that order of injunction dated 17 June 2015, passed in GA number 3378 of 2014, is binding upon all the registering authorities of India. This is the operative part of the order dated 24/2/2020. Thereafter, at page number 57, I referred an order in view. I referred an order dated 5/12/2020, in which it was ordered inter alia. In view of such, order dated 24/2/2020 is modified only to this extent that respondent authorities are at liberty to register the battery operated e-rickshaws in the name of assignee whose particulars are mentioned in Annexure P2 of the instant application. I make it clear the other portion of the order dated 24/2/2020 shall remain same as it was before. Annexure P2 of the representation. Thereafter, one SLP has been filed by one company who is a defendant in the private suit 388 of 2014, in which SLP number 27542 of 2020 against the order dated 24/2/2020, and Supreme Court, after granting the leave, dismissed the SLP as withdrawn. So Supreme Court confirmed that order as per rules and orders. And thereafter, one order has been passed on 3/3/2021, whereby the learned additional district judge Alipur, South 24 Parganas, directed all the defendants to consider my representation with regard to linkage with the Vahan e-module. And there was an unambiguous word in that order which says appropriate authority and forum. That's why we all are confusing. The state of Bihar, despite having this confusion, referred my representation for linkage to your good self. The state of Gujarat also has referred my representation to your good self. So your stand with regard to my matter has to be taken up with the state authorities' stand infructuated by virtue of a recommendation by two states and by virtue of Honorable Calcutta High Court order dated 23/6/2016 passed in WP number 23967W of 2016 strength. So in one more order I am referring, that is 27 August 2021, in which learned additional district judge South 24 Parganas clarified 3/3/2021 order stating that appropriate authority forum means Secretary, Ministry of Road Transport and Highways. So you are the authority, you are the head of the Vahan, so you have to take the call in this matter. Thereafter, till now, order of injunction is subsisting and binding. There was no order vacating that injunction. So in page number 27, Annexure P3 of the writ petition, I am referring one standard operating procedure issued by the Ministry of Road Transport and Highways, in which Ministry has stated, with the Ministry's in para number 2, with the Ministry's online registration of vehicle system provided through NIC-based Vahan system in operation in the state, the process of registration of vehicle is being carried through an IT-based system. The system is linked with the homologation system being provided by the Ministry through NIC, wherein the domestic vehicle manufacturer provides the detail of each vehicle sold in the country. So this is the SOP of the Ministry. So in the light of your own SOP, you are bound to give the link with the Vahan e-module. Because if you don't give the linkage with the Vahan e-module, the entire registration in the planned country has to be stopped from right now. Because there is a gross violation of the court's order. Until and unless, as we know from the law, because law is above from everyone, once the order of injunction is operative, government is totally bound by it. Government is bound to comply by it as per Article 12 of the Constitution of India. Because you being a state, being a government, is duty bound, obligated to protect the right of any citizen. My fundamental right, my legal right, you have to protect it because you have granted me the patent. You are the central government. Sixthly, the Government of India, Department of Industrial Policy and Promotion, Ministry of Commerce and Industry filed an affidavit before the Calcutta High Court accepting the order of injunction, saying that order of injunction is binding upon the central government and state government, and patent is very much valid. With regard to validity of the patent, I would like to reiterate that there was a Supreme Court judgment in Dr. Eloy Bobbins versus Mr. Yogesh Mehra in Civil Appeal 6718 of 2013, which is reportable, in which Section 64 and Section 107 of the Patent Act has been declared as redundant, superfluous by the Honorable Supreme Court. In view of that, my patent is very much old and it has worked for 15 years. My patent has been granted in 2012. So if you want to challenge that patent, you can challenge it by 20, within 1 year of grant of patent under section 25(2) of the Patent Act 1970. If you don't avail this opportunity, then there is no scope of challenging the said patent in the other forums. The patent will crystallize and the patent will gain finality. That is the observation of the Honorable Supreme Court. And the Calcutta High Court, in our proceeding also, in which you are the party as a central government, accepted this court's order, and it was recorded in the Honorable Court's order dated 23/2020 by Honorable Justice Subbasachi Bhattacharya, stating inter alia that government is admitting this stand placed by the patentee. So the question raised by you in your notice sent to me by email, that with regard to validity of the to explain the validity of the patent stand redressed. There is no such question. Seventhly, with regard to support of my patent, with regard to validity, the order of injunction passed by the civil court itself is a proof which recognizing my patent, because the order of injunction has been passed on a huge deliberation, on argument. It is not for the court to wait for you till 100 of year that you will appear and thereafter court will pass the order of injunction. Court has given you ample opportunity if you see the order, but you have chosen not to appear. Now you have chosen not to comply with the court's order, and I am filing contempt petition again and again. So this is the position of the government of India, that at one hand it is granting patent, and on other hand, when the court is directing the government of India is silent. What is the vested interest of the government of India in not complying with the court's order? Court order has to be complied with in true letter and spirit. We all are bound by our constitution and bound by the law, because India is a democratic country, not an authoritarian country. So whatever interest, whatever interest anyone is having, it's a different thing. It's not bearing with our patent and with our case. Our case has to be dealt with strictly on the basis of the order passed on your good self. The order which is implied on you is passed in the proceeding Title Suit 27 of 2018, in which by virtue of 24/2/2020 order, you are bound to stop the registration of electric vehicles right and now, with retrospective effect from 2015, because Calcutta High Court in a judgment dated 21st of April 2017 passed a writ of declaration stating that if you grant any registration, that will be void ab initio. The court issued the word ab initio, void. So court has also observed that court is very much satisfied with regard to my patent right. So that order was also challenged in the Supreme Court, and Supreme Court confirmed this order. So now the only option available with the government is to comply with the court's order, not to play any hide and seek game, and not to play with the citizens' right, because you are taking renewal fees from me and you are not giving me the right. That is my case before your good self. I rest with my submission. That is all.
Thank you, Mr. Sinha.
Yes.
So we have taken note of your representation. We also have your written submissions.
Yeah.
And based on the submissions you have made now and earlier, and taking into account the orders of the High Court as well as District Court, necessary orders will be passed as per law.